May I make argument for a PR bond, Your Honor? He's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court.
And what you're hearing, by the way, here, she says, may I make an argument for a PR bond? So that's personal recognizance, right? So they're just saying, can I just get out? Can I get out of custody and with a promise that I'll come back? And that's what made the judge laugh. Hey guys, been having some people asking me to review some real court scenes, so I do actually have a real court scene for you today. This one's from YouTube. The title of the video is Judge Can't Believe Her Insane Excuse for Committing a Hit and Run. So let's see what we've got.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Oh, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Clarence County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East San Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business.
Pause real quick here. So looks like what we have going on here is maybe a probable cause hearing, or it could even just be an initial appearance from jail court. Usually they don't go too much into the facts in initial appearance though, so I'm guessing that this is a probable cause hearing. At the beginning of every case, you have to find probable cause to have the person charged, right? To charge the defendant with a crime. That can be done in a couple different ways. A lot of people are familiar with the first way, and that's a grand jury. You put the case in front of a grand jury, the prosecutor gets to tell the grand jury about the facts of the case, or at least the facts as they see them. They'll call a witness, and the grand jury will decide, is there enough probable cause to charge this person? The other way, I think, is what we have going on here. This is a probable cause hearing where the judge will hear from, usually a police officer will testify. It sounds like the prosecutor is just reading the probable cause statement to the court to state what the probable cause is. In these situations, unlike a grand jury, the defendant or the defense counsel can actually play defense, right? They can actually cross-examine the officer if he or she is testifying. So there is some defense that they can play there versus a grand jury where the defense counsel is generally not even in the room.
Exited and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The complainant.
So are you telling me that now it was intentional?
Sure. The complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
Okay, so first off, the amount of damages is important because a lot of, at least our statute here in Arizona, does state that like hit and run for a particular, I believe it's a dollar amount like we heard just here, but hit and run involving a serious injury actually goes felony. So sometimes those dollar amounts help them kind of estimate, well, which direction is this going to go? Is it a misdemeanor? Maybe this state might actually have a dollar amount like If there was a damage in the amount of $1,000 or less, that's misdemeanor, and if it's damage greater than that, then it's a felony, and you could even go up in steps in felony depending on how much damage there was. So that's why they would throw something like that out. I don't know. I don't even know what state this one is in, so I don't know what their statute says, and I wouldn't even comment on their statute because I'm not licensed there. But probably that's what's going on there.
Color.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Oh, okay, so valid Texas driver's license. Looks like we're operating in the state of Texas. Okay, so that was more information than we had before.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case.
We're at a probable cause hearing. Okay, that makes sense.
Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
After.
Okay, if the judge is chewing you out, probably not the very best time to be asking a legal question to your attorney, especially if it's, I'm guessing that question is related to the driver's license. Look, your driver's license is probably the least of your problems at that point. Let the judge finish, say, I can't believe this happened. You don't have to admit guilt, but just say, Your Honor, I understand why you're doing what you're doing. Something to that effect. Otherwise, you don't want to piss him off more than he already is. Bad idea.
So sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yeah.
You, if you do have a CDL,
All right, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine.
So I can guess what they're whispering about right now. She is probably saying something along the lines of, but I'm a commercial driver. That's my job. I need my job to support my kids, sick grandma, everybody, has somebody that they're helping out, usually, right? Every court that I have ever heard where somebody has gone in there and said, but I need this because I have to take care of, they have said, the judge has said, the prosecutor has said, somebody in there in a position of authority has said, you should have thought of that at the time of the crime. Okay, now look, everybody makes bad decisions, so I'm not trying to make judgments of people or anything like that. I'm a defense attorney, okay? I represent a lot of people that have made bad decisions. I know really good people can make really bad decisions. At the same time, the statement's true. We are all responsible for our own actions. We've all got to take care of everybody around us, the people we're responsible for, right? Okay, so in those instances, if we want the judge to be thinking of our kids or whoever it is we have to take care of, we've got to think of them. We have to think of them first.
I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
This case here, not only do we have an FSGI, but it's also alleged that you back.
I can't hear that defense attorney. I'm assuming that's a defense attorney standing right next to her since she's given legal counsel. I can't hear a single word she's saying, but I know exactly what I would be saying in those situations. Please just let him finish. Just let him finish. It's going to go a whole lot better if you just let him finish. Look, if he's doing something just incredibly unjust, then yeah, hey, this attorney should pipe up and say, Your Honor, no, this, according to the statute, according to this case, whatever it is. But what's happening here is that she's in a crazy amount of trouble and still giving a really bad attitude to the judge. Bad idea.
Up and hit the person intentionally. Because allegedly hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
Okay, now what's interesting here is that I think the judge has actually given her kind of another chance. Yes, he's taken away her ability to drive, but that wouldn't matter if he was actually taking her into custody and saying, I'm holding you without bond. You were on probation and you violated your probation. I'm going to hold you here without bond. So it sounds like he's actually going to give her a bond and let her out again when she's got 2 probation violations and 2 open felony cases. If she's got 2 open felony cases, I think that means that she committed a felony while on felony release. What that means is that she got out of jail and went and committed another felony while she was, out on bond. In Arizona, that means she can be held without bond. I don't know about Texas, they might have a different rule there, but in this state, really good chance that the judge would just say, no, you're not getting out again. So I don't even have to take away your driving privileges right now because it won't even matter. You're not going to be driving for a really long time because you're going to be incarcerated.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court.
And what you're hearing, by the way, here, she says, may I make an argument for a PR bond? So that's personal recognizance, right? So they're just saying, can I just get out? Can I get out of custody and with a promise that I'll come back? And that's what made the judge laugh.
She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. She has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she's willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100.
So if you saw the note there at the bottom from the original YouTube video said, she does deserve some credit for that. In other words, she's saying, I need some mental help, and she was already trying to get some mental help. That's good. I'm really glad to hear that. She was unmedicated at the time. If she has actually taken steps toward getting medication and getting herself right, yeah, she deserves some credit there, absolutely. And the arguments that the defense counsel is making here they're all pretty good. They're arguments that I would expect to hear on maybe case 1 or case 2. Case 4, man, you're going to need something better than that.
And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it.
Okay, once again, as I said before, I think the judge was kind of giving her another chance here. He didn't hold her non-bondable. Don't know if that's something they do in Texas, but he only raised it to $5,000. I've seen clients get a $5,000 bond on a first case. 2 probation violations and 2 active felony counts. I was expecting him to say something like maybe 15 or 20.
That's always, I mean, really.
Don't say anything.
Good advice. Don't say anything. Also, objection. Your Honor, your bow tie is terrible. I'm sorry, I keep getting distracted by that thing. It's awful.
People died this weekend on the road because of the reckless and wanton actions, you know? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't
me.
say anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point,
So, she's got pretty valid points here. None of them takes responsibility off of her. Don't get me wrong. None of them take responsibility away from here. But she's trying to get the bond lowered. She's trying to get back out. At the same time, some of the things that she's saying, I don't have insurance to cover the mental health medication. That's a terrible situation to be in. That's probably the first thing that she has said or done in this entire video that has kind of pulled me in her direction a little bit. That is a freaking awful situation to be in. You can't afford the things that will actually make your head right to help you make good decisions. That sucks. Yeah, okay, that pulls me in her direction a little bit. Now I'm curious what the judge is going to say to that.
your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. It's true.
That's so
It's
not.
so true. It's so true, and you know this. You know what I'm talking about.
I've got to tell you, as a defense attorney, I've seen real racism in the criminal justice system. Okay, I know that it exists, 100%. I have also seen where judges seem to have been completely impartial to anybody that comes into their courtroom, whatever their color is, or religion, or gender, or whatever it is. I have seen most judges have acted that way. I also have seen it go the other direction. I don't know Judge Fleischer. This is the first time I've ever even heard of the man, but I am guessing that statement is probably not true. I don't know for sure, but I'm guessing it's probably not true. He probably has a lot of different people of all kinds of backgrounds come through his courtroom, and he probably has to be impartial, otherwise he'd probably get removed from the bench. So, not really buying the statement from her in this particular situation.
I call out discrimination when I see it on a daily basis, man. I don't care who it is. I don't care what color. They're a small farm animal. I don't care. I call it when I see it. The only thing, because I don't know, the way I get to know is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Everything that the judge went into right there. Wow, that's hard. That's what makes their job difficult, right? He doesn't know this lady. He doesn't know her. She just walked into his courtroom and she got, about 2 minutes of a probable cause statement. And that's what he knows about her. And he has her criminal history right there. Okay, and then the defense attorney actually did a pretty good job of making some statements to try to drag the judge back in their direction. But he doesn't know her. He doesn't know any of the people coming into the courtroom. And so one of the best things that a defendant can do for themselves is to show a little humility in the situation. To just, okay, can't believe this happened. I can't believe I'm back in your courtroom, Judge. There's no excuse. Something along those lines to just drag that judge into your corner just a little bit, to sway him a little bit. But unfortunately, instead, she's kind of been rolling her eyes and just giving a bad attitude. And so he's just saying, look, the state showed me somebody on paper, and then I was looking to you to show me somebody else. And instead, you showed me they look like basically the same person.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this.
And as you can see the note on the screen there, I forgot that she mentioned just before I paused there, that she said the officer didn't read me my rights. That might you might be able to get a confession omitted, right? You might be able to kick that evidence out if they didn't actually read you your Miranda rights, but as it says right there, they're not required to until they're questioning you while in custody. So if she hasn't even been questioned yet, a lot of my clients say, hey, they didn't read me my Miranda rights. They also didn't question you, and they're not trying to use a confession against you. If you think about the Miranda rights, most people that have watched Cops or whatever basically have them memorized, right? They all have to do with self-incrimination, telling you, you don't have to talk to us, you don't have to say anything, you got the right to remain silent, okay? Free advice to everybody, use those rights, don't talk, okay? But unless they're actually gonna use a confession against you, it's probably not even gonna come into play.
I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
you guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now.
Wow.
All right? I'm not gonna raise to $5,000.
Wow.
But I can't continue to give you a PR bond.
From employment.
Holy cow. On a fourth case, 2 probation violations and 2 active cases, and he's going to leave it at $1,000. That is mind-blowing. This judge is actually being incredibly nice to her, despite the attitude and things that the judge has been complaining about. It's actually being really nice.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new case.
Yes, sir.
And just, all right. Come on. Justin.
Wow. Okay. Really interesting video. A lot to dive into there. Difficult issues to talk about in our society, obviously, but it's things that we have to talk about. We can't just, put our head in the sand and pretend that things like racism and things like that don't exist. We also can't pretend that they exist in every single person, that they exist in every single judge or every single attorney or whatever. Wow, really interesting video. Glad we could do this. Let us know what you think in the comments, and check out my other video that we did a few weeks ago about the guy defending himself. We're doing some real stuff. Let us know if you like it, okay? And we'll see you next time.